Welcome to the Oyster Stew Podcast. I'm Bob Mooney, General Counsel for Oyster Consulting. In this episode of the Oyster Stew Podcast, Ed Wegner is joined by Lisa Robinson, Managing Director at Oyster Consulting. Lisa was the manager of the FINRA membership application team and is now our membership expert. They discuss how significant growth, whether organic or through acquisitions, can affect a broker-dealer's registration requirements. Today you'll learn when you should file a continuing member application with FINRA and what documentation is required, key elements to include in your business plan, how to streamline the application process by anticipating FINRA's request, common pitfalls and how to avoid them, and insights on FINRA's priorities. Let's get started. Ed?
Well, thank you, and hello, everyone. I'm Ed Wegner, and I am the head of Governance, Risk, and Compliance for Oyster Consulting. I want to welcome you to what has been a continuing conversation that we've been having around how investment advisors and broker-dealers should be addressing significant growth. In an earlier podcast, we discussed the impact that such growth has on a firm's infrastructure and ways firms can prepare for that impact. And today we want to turn our attention to the impact that growth can have on broker-dealers' registration requirements. And I'm very fortunate to have with me today Lisa Robinson, who's going to join me in this discussion. Lisa is a managing director at Oyster. Prior to joining Oyster, Lisa worked for FINRA and was responsible for running their membership application department. And her guidance has been extremely helpful for our clients as they've navigated tricky issues that come along with the new and continuing membership process. So I want to welcome you, Lisa.
Hi, Ed. Thanks so much. Great to be here.
So why don't we start, Lisa, with talking about it as broker-dealers consider growth, both organic and growth that comes through acquisition. What should they be thinking about from a FINRA registration standpoint?
Sure. So depending on the size of the growth, you might have to file a continuing member application with FINRA prior to whether it's a transaction or just, hiring a lot of new people. There are a lot of considerations that are outlined in the FINRA MAP rules that would determine whether or not an application would need to be filed.
So what are some of the things that when you think about those rules, what are some of the things that might give rise to needing a continuing membership application?
Yeah, so let's talk about acquisitions or mergers to start with. So FINRA Rule 1017 outlines events that would require an application for approval if there is a merger of one broker-dealer with another broker-dealer. And the exception is if both firms are members of the NYSE, or if the surviving entity would continue to be a member of the NYSE. Another event requiring application would be if there's a direct or indirect acquisition by a member of another member, or what we see more commonly, I think, is the asset transfers. And that gets a little complicated. So for FINRA requirements for an asset transfer, it's when there's a direct or indirect acquisition or transfer of 25% or more of the member's asset or any asset, business line of operation that generates revenues composing 25% or more in the aggregate of the member's earnings measured on a rolling 36-month basis. And I know that's a mouthful, right? But it's basically is if there is an asset transfer from one broker-dealer to the other, you have the receiving firm, the firm that's receiving those assets. If those assets, which FINRA considers accounts for the most part, if the value of those accounts is 25% or more of the receiving firm's revenue, then they would have to file an application with FINRA.
And I know that, as part of when we talk with firms that are going through this, that's the starting point that you work with them on, is to determine whether the transaction is going to require an application or whether the firm should consider reaching out to FINRA for a materiality consult.
Yeah, that's right. And where this comes up a lot, what I've seen is you have firms that are looking to exit the broker-dealer industry, right? So they want to file BDW, they're selling their assets to another broker-dealer, and that transferring firm, the one that's going to go out and file BDW, they think, okay, I'm done, I'm going to file BDW, that's it. Well, there's more to it. So then you have to ask that follow-up question, what about the receiving firm? What filing requirements, if any, do they have? And a lot of times they're like, oh, we didn't know that, or we didn't think about that. We better go and check. But that's a good starting point.
So there could be the situation, maybe often the situation where both the terminating firm and the acquiring firm have to file with FINRA.
That's right. So there could be a filing requirement, but from both firms. A good thing is, if you want, the glass is half full, FINRA only requires the filing of one application. So you could include all of the information you got to provide FINRA in one application, and it's usually filed by the firm acquiring or receiving those assets. And there's certain documentation that both firms would need to provide as part of this joint application.
So why does FINRA require each of the firms to file, or the filing of a joint CMA?
Yeah, that's a really good question. So for the firm that is filing BDW, FINRA really wants to make sure that there are no outstanding, unpaid, or pending customer claims or arbitrations. And if there are, how is that exiting firm going to account for those pending matters? Whether it's setting up an escrow agreement or, using a clearing deposit, that's really a focus for FINRA, is these customer claims. Another thing is FINRA wants to make sure that the exiting firm, typically they're going to transfer the accounts over via a negative consent letter. FINRA is going to want to review that negative consent letter to make sure it's giving the proper disclosures to customers about the transfer. For the receiving firm, the firm that's getting the assets, which are, again, accounts and usually reps as well, FINRA wants to make sure that the receiving firm has the right infrastructure in place to take on these new accounts and new reps. So they're really looking to make sure that the receiving firm has the right or the impact there will be to the firm's financial, operational, supervisory, and compliance systems, and how those systems can accommodate this change.
No, that makes sense. And now, so thinking, if you're working with a firm and you've identified that the growth or the acquisition is going to require an application, you've identified who needs to file, and then also now kind of understanding what FINRA is looking to accomplish in their reviews. What should firms be considering as they prepare their application? And what do you work with firms to get them ready for?
Yeah, I think it's really important to be as prepared as possible at the time you submit that application to FINRA. Most firms that are going through this acquisition and filing a BDW, they have a time frame in mind. So you want to make sure you prepare a very detailed business plan that discusses the transaction. And also there's certain documentation that FINRA will want to see as part of that initial filing. Things such as a copy of the asset purchase agreement, right? FINRA wants to review that to make sure it's in compliance with FINRA rules. A copy of the negative consent letter I mentioned before, FINRA will look at that. We talked briefly about if the firm that's exiting the broker-dealer industry, if they have any pending claims or arbitrations. Very, very important. FINRA wants to see evidence of payment. Again, whether it be through an escrow agreement or some other method, FINRA will want to see a copy of the escrow agreement. It could be a draft copy. FINRA wants to know how much the firm is going to put aside for that escrow account. They're going to want to see an arbitration plan, like what are the pending claims and what is the value of those claims. Any reps that are going to the new firm, are they on heightened supervision now? Will they be on heightened supervision when they transfer over? And a copy of the BDW. Again, FINRA is interested in who's going to be the custodian for the books and records for that BDWing firm.
It's interesting. All of the things that you're talking about really kind of harken back to our earlier discussion around sort of the infrastructure and the process around it. One of the things we talked about is the due diligence process that you go through in the acquisition phase. So a lot of these items that you're talking about are things that likely were collected as part of the due diligence phase in the acquisition. And so it's really taking all of that information and anything else that's needed and making sure that that's incorporated into the business plan, because it's the kind of thing that FINRA is going to want to see. And one of the things that you mentioned was just the timing aspect of it and building that in, because I think some of the challenges we've seen was firms with really aggressive timeframes coming in, wanting to file right away. But the challenges of getting this ready and making sure that you're prepared, because the preparation that you do before the filing is what I think we've seen to be the biggest key success factor, both in terms of getting the application approved, but also getting it approved efficiently, because this necessarily can be a time-consuming process post-filing. But we've seen situations where that preparation has really paid off in terms of the timing. Can you talk about that a little bit?
Yeah, that's exactly right. In my experience on this side of things, right, being a consultant, I really see the value in being prepared, having all the documentation ready and submitting it with the initial filing of the application. It really cuts down on a lot of back and forth with FINRA that some firms might have. We've been very fortunate here at Oyster that, when I work with clients and I say, this is what FINRA is going to ask, so give it to me now, so we could include it with that initial submission. In most instances, firms are like, okay, great, let me work on that. I'll get that to you right away. And then we have it, right? So we kind of know what FINRA is going to ask in these situations. So let's give it to them with the initial filing. Another thing that I find is so helpful with clients who have to submit an application to FINRA is to have an early firm meeting with the MAP team. So it's a voluntary meeting. I reach out to the MAP team and I say, hey, we're going to be filing an application soon. I'd just like you to meet with the firm. I work with the firm and we meet with FINRA for a half hour and we just give them a high-level overview of the proposed transaction. This way, the MAP team knows what's coming. Sometimes they might ask some really good questions that we could include in the business plan, and it's really, really helpful. But being prepared, like you said, is probably the best advice I could give.
Well, you mentioned something that makes me laugh a little bit. It's that let's be prepared for what FINRA is going to ask. And I know that in working with clients, sometimes because you're the ones asking for that during the preparation period, that you oftentimes have to say, this is not me asking, this is what FINRA is going to ask. So don't shoot the messenger. But I think you're extremely on point in terms of sort of considering what you anticipate FINRA is going to ask and including that in the business plan up front is so much better and so much more efficient than not including it and waiting for them to ask as part of the application process.
Yeah, Ed, I get clients even now, they mean well, but I'll say, listen, we need to give FINRA an arbitration plan. So let's work on that. This is what I need you to put in that arbitration plan. And sometimes clients are like, well, why don't we just wait for FINRA to ask? I'm like, but why? It's just going to take more time. You want this done as efficiently as possible. So let's go in prepared. I know they're going to ask for this, so let's give it to them. They want to know for the receiving firm what's the supervisory structure going to look like once you take on all these new reps? So let's give them the supervisory org chart. Let's lay it all out for FINRA, and it will cut back on that back and forth. I don't think it's the best approach to say, let's wait for them to ask.
Right, because the timing is such that FINRA has a certain amount of time to make their first request after you file. And so then you have to wait for that and you get it and then you respond. And then they have a certain amount of time to review that information. And the fewer times that you have to do that back and forth, the more efficient the application is going to be. And if you do not provide something in that initial application, you have to build that into your time frame as part of that. And FINRA has a certain amount of time with which they need to review these, and you don't want to be in a position where you're butting up against that.
Yeah, I tell clients all the time just to set expectations. FINRA gets 30 days to send a request letter out. I can't control how long they take to get that letter out, but it's typically 29 to 30 days. What we could control is how long it takes us to respond to those requests, right? The faster a firm responds to FINRA, it shortens the overall time frame. And again, once they send that letter, the firm is now on the clock. So if you don't have that legal document prepared yet and your attorney has a backlog, you might go over those 30 days, and that's not a good thing. So be prepared, respond as timely as you can to FINRA's requests. And we've been very, very fortunate in having our applications approved pretty quickly.
Yeah, and in terms of the things that you can control, going back to what you said before, you do have some control in terms of what FINRA asks for, because if you provide it before they ask, they don't need to ask for it again. And so your experience having seen those initial requests, and you could say, I know they're going to ask for all of these things in their first request. Well, if they're provided up front, then they don't need to ask for them. And so that'll really help it be more efficient.
That's right. And I even built in the business plan because I know FINRA is going to ask things the firm won't be doing, right? Because FINRA loves asking, please confirm you will not be doing these things. And that goes into, it's the same with acquisitions, right? Will the firm be adding new business lines as part of this acquisition? If you're not, right? If you compare the membership agreements and you're already approved for these business lines, well, tell FINRA, we will not be adding new business lines as part of this application. So it's really kind of getting into the head of what FINRA is going to ask. And it helps that we kind of know what FINRA is going to ask. So we build that into the business plan.
That might be a little bit of a scary place to be. But
Yeah,
no, I appreciate it. And all that, that's terrific. And I think that experience that you bring from having been with FINRA is extremely helpful when we work with clients. But then also the experience that you have working with our clients to date is really helpful in terms of some of the challenges that a firm may face, in addition to the timing things that we talked about before, and how firms can prepare to address them. You know, what are some of those things that you've learned about challenges, and what would you say to a client that's going into this process and what they might be thinking about?
Yeah, that's a really great question, Ed. I would say one of the biggest challenges are firms, they really just don't have a plan yet. They know they want to get from A to B, but they're not sure how to get there. Maybe they're not sure what their supervisory structure is going to look like yet, or they haven't identified the business lines that they're going to want to take on with this acquisition, or what principals will be in charge of those business lines. So that really does, it slows things down, right? Because we can't really move forward if you can't lay out what the new structure is going to look like, right? Or maybe firms haven't thought about how they're going to integrate the technology now that they're taking on these new assets. So being prepared, having a plan that you could document and evidence to FINRA is really important in the entire process.
You mentioned something that I think is really important, is thinking through the types of things that FINRA might be concerned about. And so one of the things that might be a good thing to consider is going through FINRA's priorities and seeing if there's anything in those priorities that might be triggered as a result of this, or that they might be concerned about as a result of this. You think about like all of the issues with digital assets and artificial intelligence and things like that. And those are the kind of things that, if there's any of that that's implicated by this, to be prepared, let FINRA know, and so that you're prepared for it. But if it's not involved, to make sure that that's clear.
Yeah, and that's right. And that's what I was alluding to earlier is we all know that FINRA views certain products or business lines to be riskier than others, like crypto securities, life settlements comes to mind for some reason, but these are just high risk things. So if you are thinking about engaging in those things, well, first be prepared, right? Because they're high risk, FINRA's really going to dig into them. And if you're not going to be engaging in something like crypto, let FINRA know upfront, and it's very simple. We will not be engaged in digital assets as part of this application, but having that plan. We do get clients from time to time who just throw things out there. Well, we're going to be filing an application, so let's get approval for these 10 things. Be like, okay, what's the supervisory structure? Oh, I don't know yet. Okay, well, these are considered higher risk than other products, so you need the right procedures. Have you thought about that? Oh, okay. Wait a minute then. Let me think about this a little more. So that's just a really good point. And a starting point is that FINRA priorities letter.
Well, and that's important too, because the expectation FINRA is going to have, if you're going to say, well, why don't we include that just in case we do something, they're going to be expecting that you're ready to do it at that point they approve it. So it's not like, well, we'll address that when we decide to do that. They want to look at that now. So if you're not ready for that, it's best to just hold off.
Yeah, FINRA, each application looks at a time period of 12 months post-approval. So that's what I keep saying to my clients. They're like, oh, maybe we'll operate an ATS at some point. I'm like, okay, at what point? Because if it's within 12 months, we need to include it in this application. And to include it, you have to demonstrate to FINRA that you have everything in place, including the ATS. If it's going to be 2 or 3 years down the road, we're not talking about it in this application.
No, absolutely. And that makes a ton of sense. And I think that all of the things that you had mentioned really kind of demonstrate all of the tricky things that are involved in dealing with just this aspect of this type of growth and acquisition. And so it's something that firms should really be thinking about as they continue to grow, as they continue to acquire. And it really kind of demonstrates the big benefit that having trusted guidance can provide to a client to help them navigate those tricky issues. So really appreciate you joining us today. We'll continue this conversation in future podcasts, but want to thank you all for listening, and we will talk to you soon.
Thanks everyone for listening. If you'd like to learn more about our experts and how Oyster can help your firm, visit our website at oysterllc.com. If you like what you heard today, follow us on whatever platform you listen to and give us a review. Reviews make it easier for people to find us. Have a great day.